With regard to the breach of court orders, again, we only had 8 kids, or 13%, who breached their court orders. And on the same criteria, both intuitively, if you like, as well as consulting with members of the advisory committee, we thought that this breach of court orders was also quite modest. These were kids who breached their court orders, came back to the Children's Koori Court by virtue of those breaches. Now, this is usually breaching a probation order or something of that, or it could be an undertaking or a good behaviour bond or whatever the case may be. What about recidivism, reoffending? Now, this is the thing that most people, policymakers and others, obsess about. I think one of the good things about the Children's Koori Court, if you cast your mind back to the goals and objectives, decreasing recidivism is not the sole rationale for the court, and I think that's always been understood. It's unquestionably an important one, but it is not the overriding one. And there are different bases for determining reoffending, or one can look at different types of events when you're counting reoffending. Do you just look at charges proven in further court appearance? Is a rearrest sufficient with subsequent charges, or is it perhaps just simply coming to the attention of the police? Well, clearly, if you're charged and or rearrested, you would have had to come to the attention of the police. But you can also come to the attention of the police without these latter stages proceeding. We opted to look at all 3 of these with a view to trying to ensure that we had data that would allow us to compare the findings of our study with previous data. And it was very important to try to do this, to get some comparative data, because one of the challenges or problems with the Children's Koori Court was that none of their objectives were stated operationally. And in a sense, one needed to do what in the world of program evaluation we call an evaluability assessment, part of which would have been involved getting people's judgments almost post hoc, after the court was up and running, about what would be acceptable outcomes. So let's move into this because time's moving on as well. The offending history subsequent to the initial court appearance. We found that of the 62 kids, 60% of them reoffended. A further 8 had cases pending at the time that we stopped our 2.5-year follow-up. There were also 4 had gone to court during that period where all the cases were thrown out, and there were only 13 where in the Victoria Police databases they did not appear in any further children's court or in fact magistrates court cases, because some of them, over time grew up and got older. In Victoria. Now, if they cross the border into New South Wales, they might appear in those databases. So basically, we have if you like, a very clear reoffending rate of 60%. The advisory committee was of the view that this was probably much closer to the mid-50s, 55, 56. The reason being is that it was more than likely that there were a number of cases in which the offences had been committed quite some time ago, even before these kids initially went to the Children's Koori Court, but only caught up to them after they had been to the Children's Koori Court. In other words, they were being prosecuted for offences that preceded. And that seemed to be, but nevertheless, so you might say that this reoffending rate is not 60, it's 56 for argument's sake, or 57. I think on the face of it, it's pretty high, and we'll come to whether it really is so. This is just a table, and I'll skip through that too, about the offending histories over the duration of the tracking period. And we could say some things about that, but I will skip it for purely for time reasons. Well, how does that almost 60% recidivism rate compare with other groups? We had to shop around and try to find some comparative studies, as well as the judgment of the advisory committee about whether this rate was high or low or within the ballpark or what have you. There were a number of studies, none of which are completely comparable for a variety of reasons, but There was a Department of Human Services study in Victoria which found a 65% recidivism rate, and in the report it gives you detail about how close or how different these studies are. There was a study done by Smith and Jones which compared Aboriginal or Indigenous and quote-unquote white kids offending, and found that the rate was 78.4%. We found a rate of about 60%. I don't think there is any denying that this is a high rate. It might be somewhat less than other studies, but these studies are not entirely comparable. The consensus of expert opinion, namely the members of the advisory committee, which ranged from police to academics to officers in the Department of Justice and so forth, was that 60% was actually quite reasonable, given the population that was being dealt with. In other words, it was in the ballpark. It doesn't mean that it's not inherently high, but if the court was producing a recidivism rate at about 60%, the consensus was that that was pretty good. With regard to the seriousness of the offences, there's something called the National Offence Index, which is used for rating the seriousness of offences. And we have, many of you here working at the Institute would know, there's also something called the Australian Standard Offence Classification categories. We took the offence, because most kids were charged with multiple offences. There was one case where one of the defendants had 45 charges, most of which were kind of consolidated and only a few acted upon. This was the range of the offences. As we go down this list, they become less serious. Clearly homicide or a related offence. Well, we don't actually have any, because children's courts in Victoria don't deal with those type of offences, but they deal with all of these other types of offences. And we looked at where there were multiple offences. We took the offence which was most serious, we called it the principal offence, and we looked at the principal prior offence, the principal offence which brought the young defendant to the Children's Koori Court for 62, and then we looked at the seriousness of the principal offence of the 37 kids out of the 62 who reoffended. Now, the summary of that table is here. That of the 37 kids who offended, their principal offences on reoffending, in 16 cases their principal offence was less serious, in 9 cases it was no more serious, and in 12 cases it was more serious. If you add these two together, you get 2/3. About 2/3 of the offences were either less serious, but certainly or no more serious than the offences which brought them to the Children's Koori Court in the first instance, and 1/3 were more serious. Again, the advisory committee was of the view that if most of the kids are a whole bunch of them, 43% their principal offence is less serious, and another quarter are no more serious. That was the view of the advisory committee. That was a pretty good outcome. I'm going to just jump through to the observations because I think I'm going to expire imminently, and I'll just share some select findings with you. I should also say that if you went to this study was, the data collection finished in May of last year or thereabouts. It took 3 or 4 months to do the data analysis and write up the report. If you went to the court today, which is 9-12 months later after data collection, what I report here would not be exactly the same. In other words, there have been some slight changes in procedural process as a result of this evaluation.